thank you to everyone who is joining us this afternoon. As you see, my name is Adam Mastroleo. I am a partner in our Labor and Employment Department here at Schoeneck King. I am a regular presenter during our weekly Tuesday webinars that I hope you all attend. During those webinars, we cover many of these relevant topics associated with COVID-19 and government regulations. But sometimes there are topics that are so complicated or that need a little more of a deep dive that we decide to put on a separate webinar, and that's what we're doing today. So here's the plan for today's webinar. It's a lot to pack into 30 minutes, but I think we can do it. First, we're going to go over what the current COVID-19 isolation and quarantine rules are. And I say current intentionally because these things change quickly. We will obviously provide updates if there are changes, but I'm going to talk about what is current as of this minute. I'm also going to talk about New York State COVID paid leave, what it is, and how it is administered. And then I'm going to cover some FAQs. Yesterday, I took a minute to talk on the webinar and asked you all to submit questions. We received over 100 questions. I really appreciate it. So I picked a number of the questions that kept occurring most frequently, and we're going to talk about those. So let's get right into it. What are the current isolation and quarantine requirements? Before we talk about that, it's important to understand where they're coming from, where these requirements are coming from. It's a lesson in government. We have the federal government, we have the state government, and we have local governments. So the federal government has provided us with the CDC recommendations, which were most recently updated as of January 9th, 2022. I have hyperlinked to the CDC recommendations, and you'll see throughout the presentation that I've hyperlinked to the various guidance documents. So if you are watching this presentation after I'm doing it now, and you download the slides, by clicking on Control and the hyperlinked area, you'll be able to open up the guidance documents. So we have the federal government, we have the CDC recommendations from the federal government. If you are an employer in New York State, which I assume many of you are, at this point, these recommendations, I wouldn't say you can ignore them, but they don't have any binding impact on you. Your focus is going to be more on the New York State and local quarantine regulations. So in addition to the federal government, we have the New York State Department of Health, which has put out various guidance documents. The first, and I think the most important document that came out on January 4th of 2022 is this, they call it the Interim Updated Isolation and Quarantine Guidance. And that's really what I'm going to focus on today. This is for the general population. We anticipated that there would be an update to these guidelines today at newyorkgov.isolation and newyorkgov/quarantine. But as of right now, when you click on those links, it just takes you to information regarding contact tracing. So keep an eye on that. The state may update the quarantine requirements later today, but as of right now, they have not. The New York State Department of Health has also put out guidance for specific areas, and there's two. One for healthcare workers, and again, I've linked to the December 24th and January 4th guidance documents for healthcare workers. Our Schoeneck King Labor and Employment blog actually has a really good post that summarizes what those requirements are, and I've linked to that blog post as well. In addition to healthcare workers, the New York State Department of Health has also put out specific guidance for schools. And again, I've linked to that guidance right there. You will notice that there are slight variations in guidance between the general population, schools, and healthcare workers. In particular, the healthcare workers have different return to work rules depending on the status of the situation at a particular facility. And there are contingent rules and crisis rules that may impact when a healthcare worker can return to work. Similarly, the January 10 school guidance varies a little bit from the general population guidance, and we'll talk about what the general population guidance is in more detail in just a minute. In addition to the federal CDC requirements, the State Department of Health guidance, we also have local health departments that are putting out guidance documents information for individuals within a particular county. So for example, I've linked to the Onondaga County Quarantine and Isolation Guidance, which was updated as of yesterday. Onondaga County has actually done a very nice job, and they've stayed on top of these guidance documents so that you can look specifically what Onondaga County's rules are. I will say that Onondaga County follows the State Department of Health guidance for the most part, but Onondaga County decided that they were going to put out their own guidance document, which is helpful. Another thing that, at least here in Onondaga County, that we have done is the health department put out a quarantine and isolation flow chart, which I think is very helpful for employers. The flow chart takes you through a series of questions in determining, how long somebody has to isolate or quarantine, whether they have to quarantine at all. So I would encourage you, if you're in Onondaga County, to look at that flow sheet. Erie County also has quarantine isolation guidance. There are other counties as well that have these types of documents. I am just highlighting a few for you to look at in case you haven't seen these local documents. I will note one thing, that the state's January 10th school guidance, as it's linked on the top of this page, it defers to local health departments as it relates to schools. So you really need to pay attention to what your local health department is saying as it relates to attendance at school. Okay, I want to turn now to what we're talking about when we say isolation and quarantine. This is just a very quick and brief overview of these terms, but they're important for understanding what the requirements are. So isolation refers to what somebody must do following a positive test. It's separation from those without COVID-19. It means you stay home and you be separate from others. You don't leave. And in the discussion of isolation on the CDC's website, it talks about having a separate room if you live in a household with others, having a separate bathroom, separate facilities, if those things are available. So that's what isolation is. It's following a positive test. Quarantine is required following an exposure to somebody with COVID-19. Practically speaking, there isn't really much of a difference between what you do if you're quarantined or isolated. You separate yourself. You stay home, you stay away from other people. The only difference with quarantine is that you really have to pay attention to symptoms. And if symptoms develop, you should get tested. So those are two terms that come up frequently when we're talking about what to do following a positive test or an exposure, and it's helpful as we go forward. Okay, so now I'm going to go through in detail the current quarantine isolation requirements under the New York State guidance from January 4th for the general population. So this impacts most of us. The way that the guidance is broken down is what to do if you're positive and what to do if you have a close contact. So let's start with what to do if you're positive. According to the most recent guidance, you isolate for 5 days, where day 0 is the day of symptom onset, or if you're asymptomatic, the day of collection of the first positive specimen. So it's 5 days from either of those dates, and I will point out that this is whether you are vaccinated or not. The isolation protocols that we're discussing does not take vaccination status into consideration. If an individual who is asymptomatic, individual who tests positive is asymptomatic after day 5, or if their symptoms are resolving, the isolation ends and the individual should wear a well-fitting mask while around others for an additional 5 days. I will point out, in the guidance talks about this, that loss of taste or smell may persist for weeks or months and should not delay the end of isolation. This is important because ending isolation is tied to the resolution of symptoms. So the Department of Health wants you to know that just because you still can't taste or smell doesn't mean you shouldn't end your isolation. Individuals who are moderately or severely immunocompromised should continue isolation for 10 full days. So they don't get the benefit of this reduction to 5 days. Similarly, if you are someone who cannot wear a well-fitting mask, you need to continue isolation for the full 10 days. All right, so that's what the New York State Department of Health is saying to do if you test positive. Now let's turn to what the Department of Health says to do if you are a close contact. So if you're a close contact, it's going to depend on your vaccination status. So if you're not fully vaccinated, or you're fully vaccinated and eligible for a booster, but not yet boosted, if you have a close contact, you have to quarantine for 5 days and wear a well-fitting mask for another 5 days. If you are fully vaccinated and boosted, with a booster at least 2 weeks before exposure, or you're not yet eligible for a booster, you don't have to quarantine following a close contact with a positive case. The guidance also recommends testing after day 5 with a PCR or antigen test. Does not require it, it recommends it. And it states that if symptoms appear, you have to continue your quarantine and seek testing. So these are the two scenarios that the New York State Department of Health guidance currently addresses. What to do if you're a positive case, or what to do if you have close contact with a positive case. Now, I will point out that the guidance throws a little wrinkle in that may impact those of you either in the school setting or in the healthcare setting. Here's what it says. It says, note that work restrictions or school attendance requirements for an individual might be different from isolation or quarantine requirements for that individual. So in other words, if someone works in healthcare, we talked about that separate healthcare return to work guidance document. They may be able to return to work before they would otherwise be out of isolation under the general population guidance we just discussed. And that is what the state is telling us with this paragraph. Just make sure that if you are dealing with a school or attending a school, teaching in a school, or you are in the healthcare setting, that your quarantine isolation requirements might be a little different than the general population requirements. So that's something that you need to keep an eye on. All right, so with that, we're going to now turn to COVID-19 paid leave. And I'm going to give a quick overview of the various laws or regulations that relate to COVID paid leave. Now, first, the federal FFCRA, so Families First Coronavirus Response Act leave, is no longer available. If you remember, that was something that the federal government put in place very early on in the pandemic. It provided paid leave for employees under certain enumerated circumstances, such as if you were seeking medical treatment, or if you were sick for COVID, or staying home with someone or taking care of someone with COVID. The FFCRA leave expired on September 30th of 2021. So it is no longer available, and it is no longer something you have to worry about. We've received questions about whether that is still ongoing, so I thought I'd point that out, that it is not. All right, now let's talk about New York's paid COVID leave law. This is actually a statute that was passed by the New York State Legislature and signed by Governor Cuomo on March 18th of 2020. So this was right as the pandemic was starting. It's important to point out that this was actually a statute, because we're going to talk about guidance later on. But this is the actual law. The actual law applies to public and private employers. It states that employers must provide up to 14 days of paid leave, or the amount of leave that someone would, the amount of time someone would work within a 14-day period, depending on the size of the employer. So there are different rules for employers who have between 0 and 10 employees, 10 to 99, and over 100. There are also different rules in those lower employee categories based upon income. So double check based upon your size exactly how much leave you are required to provide under this New York paid COVID leave law. What the law says is that employees who are subject to a mandatory or precautionary order of isolation or quarantine issued by the state of New York, Department of Health, or any governmental entity authorized to issue a quarantine order are entitled to the paid leave. This is going to become important. We're going to talk about this a little later in the FAQs, but the statute itself limits COVID paid leave to only those who are subject to a quarantine order or isolation order issued by one of those enumerated bodies. It does not talk about employees being entitled to this leave just because they're symptomatic or just because their doctor gives them a note. According to the statute, employers are only entitled to this leave if they're subject to a quarantine or isolation order. The law states that this leave has to be job protected. In other words, you cannot terminate someone for taking this COVID leave. It cannot be charged against other leave, including sick leave. And this is something that's been very frustrating for New York employers because unlike the federal leave that we talked about just a moment ago, New York doesn't offer any tax incentive for employers to provide this leave. The state is just telling you, you have to provide it. And therefore, employees in New York State are in theory getting additional paid time off that they otherwise would not be entitled to receive. The amount of leave is the amount the worker would have otherwise received during that period, either 5 to 14 days. And importantly, I've received this question a lot. There is no expiration date on the statute, at this point. So for now, this law or this leave still has to be provided by employers. So with respect to this New York COVID paid leave, we have the text of the statute, we have the law, and I just went over with you what the law says. We also have a guidance document that came out in January of 2021, and it was issued by the New York State Department of Labor. These are the only two documents that we have to provide us with any information about this paid leave: the guidance document from the Department of Labor and the statute itself. There are some FAQs on the New York State Department of Health website as well, but the guidance document that I've linked to here and the statute are the only official documents. So according to this guidance document from the New York State Department of Labor, New York State COVID leave is available only up to a maximum of 3 times. This doesn't come from the statute itself. The statute doesn't say how many times an employee can get it, whether it's 1 or an unlimited amount of time. But the New York State Department of Labor has said in this guidance document that it's only available up to 3 times. The guidance document also says that the second and third times must be due to a positive test. So in other words, if you have an employee who is subject to a quarantine order because they were exposed to somebody with COVID-19, that would entitle them to receive New York State COVID leave the first time. But the second and third times, they would not be able to receive New York State COVID leave if they were subject to a quarantine order because of an exposure. It has to be the result of a positive test. And that's something that is actually helpful for employers because it limits the circumstances under which you have to provide this leave. Now, the guidance document goes a little further than the statute, and I have it bulleted here. It says that if an employer mandates an employee who is not otherwise subject to a mandatory or precautionary order of quarantine to remain out of work due to exposure or potential exposure, the employer must continue to pay regular rate of pay until the employer permits the employee to return to work or the employee becomes subject to a quarantine order. So we just talked about the statute. The statute says COVID paid leave is only available when there's a quarantine order. The Department of Labor's January of 2021 guidance ignores what the statute says and states that employers have to provide paid leave, even in the absence of a quarantine order, if you as the employer send somebody home due to an exposure. Now, the guidance does not say whether or not that has to be COVID leave per the statute, or whether you can require an employee to use their own PTO in those circumstances. So it's silent on that. All right, other COVID-19 paid leave that's available is New York paid family leave. So we talked about the FFCRA, which was the federal paid leave. That's over and done with. We talked about New York State's COVID leave statute. There is also New York's paid family leave, which is available where an employee must care for a dependent under a quarantine order. There are also other qualifying rules. And New York State has a form for your employees to fill out to request COVID-19 quarantine paid family leave. Now, paid family leave is obviously different because it's an insurance program. Employees have to apply for the benefit. It's different than the New York State COVID paid leave we just talked about. Similarly, disability, the state is allowing disability benefits under certain circumstances. Okay, so that's a general overview of the COVID paid leave rules. And now I'm going to hit on what I have seen over the past several weeks and what I know many of my colleagues have seen as the most common questions. And these common questions are very good questions. And I will point out that when we receive these questions, we, like you, understand that all you're trying to do is the right thing. You want to make sure that you're following the law. And I'm going to preface how I address these questions by saying sometimes there isn't a very clear answer. And in those situations, you really should consult with legal counsel. Let us walk you through the risks and benefits of a particular approach and help you through that decision. So first question we've been getting the most: do I have to accept the self-attestation forms? So first of all, let's talk about what are self-attestation forms. Many county local departments of health are saying that they are inundated with positive cases and can no longer keep up with issuing quarantine and isolation orders. This makes sense, particularly given the explosion of positive cases all throughout the state. Onondaga County has had its highest number of positive cases multiple times over the past several weeks. So what Onondaga County and many other counties have done is they've put self-attestation forms on their website. And I've linked to the county's forms here in the presentation. These forms are for someone who tests positive to fill out that says, I tested positive and I am subject to, I will remain isolated for 5 days. Now, the question that employers run into is, wait a second, is this a quarantine order? Remember, Adam, you just told me that the New York COVID leave law only applies where someone is subject to a quarantine order. Are these self-attestation forms quarantine orders that would entitle somebody to COVID pay? Well, here is our first situation where neither the statute nor the January 20th guidance from the Department of Labor addresses this issue. I will note a couple of things that are relevant to your decision of whether to accept these self-attestation forms for the purpose of COVID pay. First of all, the self-attestation forms, both in Onondaga County and other counties, Erie County, for example, says that it is, quote, legal documentation, and, quote, as if it was an individual order for isolation issued by the Onondaga County Health Department Commissioner of Health. So the county health departments are trying to make it look like these are orders and legally sufficient to entitle individuals to COVID pay. But they're not actually orders. I mean, that they are self-attestations. I also would point to the language of the statute, which says that an employee, in order to qualify for these benefits, must be subject to a mandatory or precautionary order of quarantine or isolation issued by the state of New York, the Department of Health, local board of health, or any governmental entity duly authorized to issue such order due to COVID-19. That doesn't say self-attestation, so it's beyond the language of the statute. The guidance that we've talked about from January 20th of 2021 states that the second and third positive tests must be based on documentation from a licensed medical provider or testing facility, attesting that the employee has received a positive diagnostic test for COVID-19. Again, it doesn't reference these self-attestation forms. Now, I will also point out that the same guidance, as we discussed just a moment ago, expands beyond the text of the statute, but it's important to point out. Now, the self-attestation form entails concerns that the Department of Health orders do not. And those concerns are that it is not an actual order. For those of you who have seen these quarantine orders in the past from your local health departments, they're serious documents. They say things like you can't leave your house. If you leave your house, you may be subject to civil penalties and fines. I know that local health departments were engaging local police early on in the process to monitor whether people were complying with these quarantine orders. A self-attestation does not address any of those issues. So the question that was asked, and the question that's been asked by a lot of people, do I have to accept the self-attestation forms for purposes of COVID leave? And the answer, it's not clear. So you need to really talk to legal counsel and develop what you are comfortable with as an approach, because it might differ based upon your circumstances. It might differ based upon the circumstances of the individual. So I wish I could give you a, here is the answer in response to this question, but it's not that simple. Okay, the next question I've been getting a lot, and I will say this right now, we're scheduled to go to 12:30. I'm gonna go a little over, I hope that's okay, but I do wanna get through the questions that I have here on the slides. Do I have to accept an at-home positive test, again, for the purpose of COVID pay? And I've had clients call me and say, wait a second, how do I even know that this person took this test? How do I know when they took it? There's no date on it. There's no way that I can tie it to the individual. So there is a significant risk of falsification here. However, from an employee's perspective, it's difficult right now to obtain a PCR or rapid test. They are not as easily or readily available as they were 4 or 5 months ago. So here are some possible approaches. And remember, these are just possible approaches. They're not intended, I'm not intending to give you every possible approach. These are some possible approaches. You could accept the at-home test with nothing more. That's something you could do. You could accept the at-home test with additional proof. You could require a copy of the positive test and proof that the individual has self-reported a positive test with the county health department, or make them provide a picture ID. The reason that you'd want the county involved is because that's an added layer of security. You would have, the employee would be required to report to the county health department that they tested positive. That's more serious than just telling their employer. So that's an added layer of security. You could conditionally accept an at-home test and provide COVID pay, but also require a positive PCR or rapid test to confirm. That is a potential approach. Another potential approach is to say, no, I am not going to accept the at-home test. I'm going to require you to stay home, employee, and use your PTO until a positive test is received. So that's another possible approach to these at-home positive tests. Again, this is a situation where the guidance and the statute do not provide a clear answer, and your approach may differ based upon the circumstances. Okay, next FAQ. What do I do if an employee calls and says they were exposed to someone with COVID-19? Well, first of all, you need to ask questions about the nature of the contact. Not about who it was with, but is it a close contact as defined by the state? So the state says that a close contact is someone who shares the same household or were within 6 feet of a case for 15 minutes or more over a 24-hour period. So if, let's assume that someone is a close contact, you make that determination. You then have to understand the different requirements based upon vaccination booster status that we talked about earlier. And if an employee is required to quarantine based on guidance, is the leave going to be paid as COVID paid leave? Now, you may require the employee to complete the self-attestation form if that's available in your county. Is it New York COVID leave? Well, you may pay COVID leave until test results, until you receive test results or not, based upon the January 2021 guidance, which we talked about, you may pay COVID leave based on the attestation form for 5 days. So in other words, the individual would complete the quarantine attestation form that said they had a close contact. And as long as they remain asymptomatic, you'd pay them for those 5 days, and then they'd return to work. Okay, if an employee who tests positive remains symptomatic after 5 days, do I have to continue to pay New York COVID leave? Remember when we talked earlier on about the new guidelines. If someone after 5 days is either asymptomatic or their symptoms are resolving, they can end their isolation. But this question deals with the alternative. What if they test positive and their symptoms are not resolving after 5 days? Again, neither the statute nor the January 20th guidance addresses this factual situation. The current isolation rules only allow an individual to break isolation after 5 days if they're asymptomatic or symptoms are resolving. An employee whose symptoms are not resolving has to continue the isolation. So again, this is not addressed and there's no clear answer. Whether you continue to pay for the remainder of the 14-day period required by the statute, or is it a 10-day period? It really is not clear. And you need to discuss the specific factual circumstances with your counsel. I would also direct you to the January 20th guidance for instruction on individuals who continue to test positive, because that guidance addresses that situation. Do I have to pay COVID leave if an employee is positive but is able to work from home? This is a good question. These are all good questions, but this one I can actually answer. If the employee is able to work from home and is healthy enough to work, then they can work from home and no COVID pay is required. But if the employee is able to work from home but not healthy enough to work and is subject to an isolation order, then they'd be entitled to COVID pay. And we've received a lot of questions. Well, how do we know if the individual who can work from home is healthy enough to work? You're going to have to rely on the employee and what they're telling you about their symptoms and ability to work. Because in this circumstance, you have an isolation order, you have someone who otherwise could work from home, and it's really about symptoms and what the employee is reporting to. All right. Do I have to pay COVID leave for an employee who tests positive, but who voluntarily chose not to be vaccinated? Again, this is a difficult question. I will say this, there is no exception in the statute or the guidance for unvaccinated employees. In other words, the statute doesn't distinguish between quarantine orders issued for those who test positive who are vaccinated and unvaccinated. The statute says you have to pay COVID leave if someone is subject to a quarantine order. Whether you want to be incredibly aggressive and say, I'm not going to pay you because you made the choice not to get vaccinated, that's a difficult decision to make, and one that I would recommend you only make with the advice of counsel. All right, so that is it. I apologize for going a little bit over. Again, we appreciate you being with us today. We hope you found this helpful. Please check the website tomorrow if you want to see a recording of this webinar, as well as the slides, so that you can access the links that I referenced in the PowerPoint presentation. Thank you again for attending, and we hope to see you next Tuesday at our regular weekly webinar.